Everybody mind?
Okay, it's 6:05. Call the meeting of the Planning Commission to order. First item is approval of the agenda. Here's a motion to approve.
Motion to approve.
Second.
Second.
All in favor, say aye. Nay. Agenda is approved. Opening business, approval of January 2026 meeting minutes. The minutes were distributed electronically. Everybody had a chance to read them. We hear a motion to approve the minutes.
Make a motion to approve the minutes.
Do we hear a second?
Second.
All in favor, say aye. Okay. All right. I don't see anybody signed up for public comment. Old business, none. New business, subdivision ordinance updates. Review and discuss proposed changes. Get the crosswalk if you can.
I think that's probably your easiest. I provided a crosswalk in addition to the actual subdivision itself with the attorney's comments. I do have that available if you prefer that yourself.
Okay, there are lots and lots of changes. Do we have to go over each and every
Every
one?
one of them. Well, I put that crosswalk in there because a lot of it is nothing more than just clarification. I think we have a few things that we need to discuss.
All right, would you guide us through those?
All right, so we'll just go through, I'm not going to go by one, I'll just go through the article. So Article 1 is your, let me get to it, basically your title of the ordinance and of the subdivision ordinance, and then your jurisdiction. All of those amendments are basically just clarification, removes redundancy, but there's no policy changes to it. Article 2 is purpose. Basically, there's revisions to it for clarification, formatting issues. There wasn't any impacts to that. It's just edits. And then in Article 3, the interpretation was also reworded. It's just to define governing, clarify certain words, standardize measurements, statutory references, and removes I can't say that word. Never mind. And I can't say it. It just won't come out. I have a lot of issues like that. So all of these are just legal clarification edits.
So the second column is the new approved.
Yes, you will find in the ordinance, basically you've got the way I set the crosswalk up is the current language, the proposed language that the attorney produced, a summary of some of the situation as to why it was changed, and then if there was any impacts or other notes from me. Moving on to Article 4, definitions. Definitions were basically clarified, some of them, and the reason that we're actually doing the subdivision changes when I sent it off was because of a policy change from the 2025 legislation, and that was 15.2-22201, which made changes in development for subdivisions, requiring that the subdivision agent or agent review a lot of the subdivision and it not come before the planning commission. So basically it's fast tracking developments, and that was done. It was supposed to have been adopted in July of 2025. We didn't get to it, so therefore we're working on it now.
Okay.
During his review, he found a lot of other issues with our subdivision that had not been updated since 2014. So a lot of changes in legislation had happened. and he has made it as compliant as possible currently. So there was a question that he proposed about, we have agricultural purpose. Wanted to know if this agricultural purpose was clarified based on the Agricultural Farm Act. It's called the Right to Farm Act, Code 3.2-3300, which defines an agricultural as a bona fide production of crops. We have a definition that we have amended, and he asked whether or not we had agritourism and agricultural purpose in the zoning ordinance. And so moving on into this, you'll see where we're going to have to amend the zoning ordinance because of some of the developments criteria that's in the subdivision ordinance. Technically, by law, isn't allowed to be in the subdivision ordinance. These standards need to be in the zoning ordinance. So if you went through the crosswalk, you'll see where, or the subdivision ordinance itself, you'll see where he cites certain court cases that would say that these aren't allowed by the Supreme Court. So we're moving on. So some of the definitions that we're adding or clarifying would be again, agricultural purpose. We would be also clarifying building. That he asked whether or not that also lines up with the zoning ordinance. It does not. So we will need to either model this same definition in the zoning ordinance in addition to the subdivision ordinance, or we can create a new one. It's entirely up to the planning commission. Do we have any comments on that one? So as we go through these, I want to talk a little bit about them. Do we want to just model the zoning ordinance to this particular language that he placed? Or do we want to make our own for this particular definition?
I would think we use his.
All right. All right. So we will model this definition and the zoning ordinance together. Clarification, he asked about building setback line. Basically, he removed "so otherwise established by law" and added the building setback line shall be the same as the applicable setback in the zoning ordinance. He suggested that, and you can see his markings. He suggested this to be what we should say if they have covenants. And that's different line, that's their business and not ours. So they know that if those covenants are more stringent than our regular setback lines, they have to contend with that. All right, he added some clarification in the certificate of site improvements. Basically, this protects the county. If a developer didn't finish out the project, the funds would allow the county to have the ability to finish the project out ourselves. So he did a clarification on the certificate site of improvements and stated that an engineer's estimate reasonably satisfactory to the county or other public agency with ultimate responsibility for the ownership and the maintenance of the improvement. That was the addition to that particular definition. Nothing more than just clarification. He added Code of Virginia, which is a new definition that's not been in the subdivision ordinance. And that just states that the Code of Virginia represents the Code of Virginia of 1950 as amended. The next one he added was just a clarification and references the Condominium Act. Basically, in accordance, the condominium which basically defines a condominium, but he also adds in accordance with the Virginia Condominium Act, Chapter 19, Title 55.1, and then of the Horizontal Property Act, Chapter 20, Title 55.1 of the Code of Virginia. Nothing more than just clarification, no impacts. Development was the next one, just basically clarification, just a few words struck and added. And this is the easement. I don't know if that's something we need to talk about, Mr. Surveyor. If there's anything that you saw in this particular definition that would be alarming.
No, not under easements.
Okay. All right. So that's nothing more than just a clarification. Farm division. Basically, he just struck some of the redundant language and just clarified it. It went from a paragraph to a sentence. So now it's a division of one parcel into 4 or fewer parcels, each of which is 10 acres or more in size. It said the same thing before. It's just less words. Family division. This is the one I really wanted to talk to the Planning Commission about. It's something that I've seen come through quite frequently in my role as a subdivision agent. So basically it is, a division or a lot or a parcel that is divided as a gift to a family member. So I've noticed in other subdivision ordinances in and around the area, and I provided you in the folder, family division clauses taken out of certain subdivisions. One was Carroll, one was Smith. Galax doesn't have one in there. I could not find a family subdivision clause in their subdivision ordinance in Washington. So one thing that I have ran across from time to time is people will subdivide those for their family members, and there's a clause inside of the regulations of the state that would allow a body, a governing body, to add additional language, and this is out of 15.2, 2244.2A7, and it would allow us to add regulations that would keep a family division from being sold. So you can go up to 15 years, but from what I have seen in some of the local jurisdictions around us, that they have to retain it for 2 years before they can actually sell it. And basically that just circumvents people from subdividing property as a family division and turning around and selling it, which would necessarily could be a subdivision of class 1 or a class 2 subdivision. Is there any concerns with adding that language that the Planning Commission would have?
Are you thinking of 2 years or more?
I would probably model after what Carol's doing, Washington's doing.
Is that 2 years?
2 years.
Oh, 30.
The way, when you go into your folder, I added, well, I say go into your folder and I can't even get mine to come up. Under subdivision files, I added family division info this evening.
What would happen if the person becomes deceased?
That's where I'm going. Good question. It talks about, get my specs on so I can see. All right, for the purpose and sale of gift to a member of immediate family as defined in 15.2, 2244, of beneficiaries of a trust of land held in trust. All trust beneficiaries, 1, must be an immediate family member as defined in 15.2, 2244. Agree that the property should be subdivided, and 3, agree to place a restrictive covenant on the subdivided property that would prohibit the transfer of the property to a non-member of the immediate family for a period of 15 years. Notwithstanding the provisions of the clause, a locality may reduce or provide exceptions to the period of years prescribed in such clause when changed circumstances so require. Upon such modification of a restrictive covenant, a locality shall execute a writing reflecting such modification, which writing shall be recorded in accordance with 17.122.7. The locality may require that the subdivided lot is no more than 1 acre and otherwise meets any other express requirement contained in the Code of Virginia imposed by the local governing body. So
Where did that come from?
that is out of the Code of Virginia under 15.2, Chapter 22, Article 6.
Okay.
So if there was a situation that arose, the way I interpret that, and Justin or someone tell me otherwise, that there could be a modification and would have to come back through to the administrator to make that change.
I think that's how I understood.
Okay.
You lost me about halfway through.
I mean, I want to talk about it. I'm not saying that's what we're going to do, but
Right.
if the planning commission feels like, hey, that might be something we want to add, just so that we're not seeing these properties turn hands
Mhm.
frequently.
Well, one other thing is what if somebody, what if they need the money bad and they got to sell?
For about 2 years.
Or could that affect them and give them a loan too? They're gonna build a house on
I don't think it would affect them for that. To hold it for 2 years? Carol says that must be retained by the family member for a minimum period of 2 years after the conveyance and not be sold or transferred to a non-family member within the period without the express written permission of the administrator, which permission shall only be given after following the same provisions and applying the same standards as herein required for the granting of a variance. All other requirements of this ordinance shall apply. Lot created.
So that gives you.
That would give me the ability to give a variance, make the
it. You
decision,
can see what's actually going
what actually is happening, what's transpiring. Say, Justin, you hit a hardship
on. Right.
and you have these 5 acres that's been gifted to you by your family. And this hardship that's posed, you've lost your job, you're that sort of thing. You need that extra income to support your family.
So you could reduce the 2 years.
But the hardship we would need, we would have to kind of know what's a hardship.
Bank account, printing or something.
That seems to protect both sides.
Right. That's
The Smith County, family of the property owner shall be subdivision agent for approval. Only one such division shall be allowed per family member, which is state code. Shall not be for the purpose of circumventing the section. Any subsequent divisions of property on such right of way or street shall be subject to review by the subdivision agent to ensure. They require in Smith County that when it's divided, they shall have a highway entrance permit, a sewage disposal permit, zoning approval, and prove they have access to water before the planning commission approves the redivision. However, the planning commission isn't really by code now allowed to actually do that because of the current 2025 legislation. So it would have to be the agent. So that tells me they've not updated their ordinance either. Washington County, they can go into 2 lots for the purpose of selling gift to a member of the immediate family. Submitted to the subdivision agent for approval. Only one such division shall be allowed per family member, not to circumvent the ordinance. Any subsequent division of the property has to have a right of way or street shall be subject to review. The subdivision agent and complies with provisions of this ordinance, and that such redivided lots shall have highway entrance. You know what? I've copied and pasted that twice. That's not right. I'm thinking they had 2 years. Anyway, neither here nor there. There are other localities doing the 2-year clause.
I like the 2 years, cause that's enough to know they wouldn't be doing it just to circumvent the ordinance. It'd be long enough. They'd have to keep it
And
for
there's
that
a way if somebody did get involved.
Right, and so,
And I think they need the language about the water and the entrance and all those things.
I find that a little harsh,
It
actually.
is too much.
I do, because
Kinda like Carol's.
that, you like carols? I find that a little harsh just because that is cost.
That's true.
It's cost to the owner, the new owner, and that might be something that these, and you have to remember that a lot of these family divisions I see come through are for children. And these children can be below minimum age requirements. I mean, they can just be in there and grandparents are giving it to them. They can have rights to it after they turn 18.
They're not planning on
You're
developing it.
putting a hard, in my mind, that's a hardship that would be given to the parents, that they would have to show they can get water, that they can get an entrance on it. I think as long as they have a right of way or an easement that we'll discuss here in a minute, that I think if they have those provisions in place, it's a minimum of 2 years, that kind of sets them in a box for a little bit. But also having the ability, if there is a hardship, to be able to have an administrative approval that yes, this can be done for that person.
As long as that's in there, I like the 2-year thing.
But I want to discuss that with the attorney,
Yeah.
how it needs to be modeled.
Are we in agreement that 2 years with the other language?
All right, anybody over here on this side? Good. That's something I've been wanting to do for a while, but just never had the opportunity to. All right, let me make myself a note.
Gotta beat the boys out the makers.
Okay, they don't let me do it. Two years and a variance. All right, moving on. The next one was final plat, a lot of clarification. Basically, it just needs to meet the requirements of recording in the clerk's office. He was added that. He also added a clause in here about homeowners association, property owners association. Basically, the property owners association seems to be more increasingly common in commercial and recreational subdivisions. He also added in Property Owners Association Act under Chapter 18, Title 55.1 of the Code of Virginia. Improvements was looked at. Another clarification, ultimate ownership and maintenance of a public entity. For example, county or VDOT or the homeowners association in case of private roads and stormwater management improvements. That was an additional verbiage added to the improvements definition. Again, nothing but just words, clarification. Infrastructure, nothing more than just clarification on that part. Clarification on lot on record, adding the verbiage of Office of the Clerk of Circuit Court. The other big change I noted was manufactured home. He completely nixed our entire definition, and it matches now the Manufactured Home Lot Rental Act of Chapter 13, Title 55.1 of the Code of Virginia. Does anybody have any issues with that? It's state language. Additionally, we probably need to model the same definition in the zoning ordinance because it does not match. Everybody good with that?
Yep.
Okay. He added language to the word owner. For clarification, basically this new verbiage places the responsibility on the owner. He added, unless otherwise stated, it does not include a person whose sole right is a lien holder or a trustee for a lien holder. If a lien holder approval is required for any action under the ordinance, it's the responsibility of the owner to obtain such approval. The other one that you probably looked at and read was the plan unit development. He gives a whole synopsis basically on plan unit development. Additionally, based off of what he has said, that the two court cases that he gives, which is Chesterfield versus Tetra Association, was in 2010, and then the other one is the Board of Supervisors out of Augusta County and Courtside Investments. He basically says that the Supreme Court of Virginia said, in essence, that plan unit developments was beyond the subdivision ordinance could address it, that it must be addressed in all of the zoning ordinance. So my proposal to you is to take all of these changes that he is suggesting in the subdivision ordinance, creating a section in the zoning ordinance, which would now be like 13-11.4, I think is what it will be. I've started adding that verbiage in there, but everything that he is saying that needs to go to the zoning ordinance, I'm creating a whole new section in the zoning ordinance for plan unit developments, Class 1 and Class 2 subdivisions. And if you'll note, in all of his verbiage that he sends to the Planning Commission for review, it's all design requirements. The design details cannot be in a subdivision ordinance. It has to go to the zoning ordinance. You're thinking really hard, Justin. What are you thinking?
Trying to take it all in. So this wouldn't be under subdivision ordinance at all. We would just implement that into the zone.
Yeah. I mean, there'll be some plan unit development information in,
It would have to be mentioned.
but
so
it's
that-
mentioned, and
Okay.
you'll have to reference the zoning ordinance to get the design requirements for a plan unit development. That makes sense?
Yeah, that was what I was thinking. So if it's not on here, nobody would know they could do it if they look at subdivision
Right.
ordinance.
But they'd have to reference the
It just
zoning
said
ordinance to get
Refer
the
to the zoning ordinance for.
design
regulation.
requirements. All right, again, preliminary plat, he adds clarification, no impacts to that, basically just saying that it's now, he struck intended to incite and added the ordinance and shows the plan of subdivision and development that will ultimately be embodied in the final plats. A lot of just clarification. Private street, clarified that. Is there anything that we need to worry about on private street, Justin? That you see as an expert in land use? He just simply states that the private streets are not publicly maintained.
Yeah.
All right, here's the one that we were talking about earlier today, right of way. A piece or strip of land set aside, and he added in fee simple for the use as a street, utility easement, or other public use.
What does in fee simple mean?
It means that whoever's getting that piece or strip actually owns that piece of land. And that was my only concern that I seen in the whole thing was we put in And see, in subdivisions, it does become fee simple, which means the county or VDOT's gonna take over those roads. But if we keep the single division,
Mhm.
in our ordinance, we have to have a 30-foot right of way or access easement to that piece that we're cutting out, if it doesn't have road frontage. So if we put that 30-foot strip in there, you know, if we was to call it a right of way, by this verbiage, it would actually become a strip of land that whoever buys the piece of land we're cutting out would actually own that strip of land, as opposed to having an easement for ingress and egress. So the fee simple just means ownership, whereas an easement is giving you a right to cross.
Right.
Or,
So you recommend to keep that?
well, I think we would, I don't know, we need to ask him, see what he
Yeah,
thinks.
and so that's,
Just mention that fee, you know, he knows what fee simple is, and any other subdivisions we do would probably be fee simple, except for, or even our family divisions. You know, if we put in 20 foot, we either need to just start wording on the plats that it's a 20-foot access easement as opposed to a 20-foot right of way. But a right of way can be in fee simple, or it can be an easement.
yeah, because he's got a strip of land set aside in fee simple, which is that strip that they own for use as a street, utility easement, or other public use.
Yeah.
And that's what he's changed, because originally we had it as a piece or strip of land set aside for use as a street, utility easement, or other public use. Which would make the fee simple, the way you're describing it as the definition,
It's
It-
creating ownership
Yeah,
for
it's-
somebody.
to
Is that
somebody.
better than an easement?
Well, you're saying if I gave you Dan the right of way, he would
By
own
this
that
verbiage,
right.
he would own
You
that,
would own that right of
the
way.
land,
Yeah.
not just.
You wouldn't just have the right of way through,
Right.
you would be owning.
And I may be misinterpreting this, but like, you know, with their power lines and stuff, those are easements.
Correct.
You know, the landowner owns the land, but the power company can come in and do clearing or whatever they
So
gotta do.
if it's in
Maintain
fee
their
simple, I
own it.
own it.
You own it, you could maintain it, you could throw gravel
You
down,
could do whatever.
you could do whatever in that strip. And that might not be what
If
the
I-
intention was
So what you
for
drive through.
the, yeah,
For ingress and egress.
If I sold it, do I have to sell that part of the parcel?
it would go,
Stay with
yes,
whoever
it
has
would
the
go
right of way.
with the land.
Okay, all right.
Transfer ownership. So I know me and Justin's had a few conversations about it, and I know he was uneasy about it, which once he'd explained it to me in those layman's terms, I'm thinking, we might want to have a conversation with the attorney about how we need to either, I mean,
Well, he put fee simple in there, right?
right, yeah, he added it for clarification, and I said that it was no impacts, but there is technically impacts to that.
Mainly with their single division. Again, if it's a subdivision, those streets do get dedicated to either the county or VDOT.
Right.
If we're cutting out an acre that's 1 mile off the main road and we've got a 30-foot right of way or easement to it, if we keep fee simple, it's implying that who owns that piece of land owns that strip of land, and the adjoining landowner may or may not have the easement to use that same road.
Okay, so
That sounds like.
And most of that is clarified in a deed when an attorney writes up the deed. You know, if I'm showing a 30-foot right of way for a cut out piece of property, then they will clarify by saying 30-foot right of way for ingress and egress. So that cuts it down to, it's just for them to come in and out.
In and out.
Doesn't give them ownership.
okay, if I own 10 acres and guy behind me buys 10 acres with a right of way fee simple.
Through.
What if I say, I don't want him taking my land?
Well, you wouldn't have to though in that case. We're talking about, say you own the land
Yeah,
and you want to cut out 5 acres for a family member or whoever,
or some stranger, whatever, you know.
and they have to have, by the ordinance, has to have a right of way from a state road to that,
Okay,
or an easement.
okay. But if it says fee simple, that means he owns that strip of land,
Right.
and I don't want to
That's
sell it.
right. And that's where I'm saying we either need to start, like on our survey maps, put that it's a 30-foot access easement for ingress and egress, as
Right.
opposed to a 30-foot right.
Right of way.
Right of way has a little more, it's more restrictive as to, well, actually easement is more restrictive to what you can and can't do within that easement. A right of way is a little bit more.
They have a little more
Yeah.
teeth and leeway to be able to do things.
So you think we ought to drop the fee simple?
I don't know if it's drop the fee simple or
Or just imply that.
just when
Fees-
we do subdivision
would be fee
reviews,
simple.
that the surveyors now know that there's been a change in the subdivision ordinance and that they need to know one way or the other. Either you're doing this as a right of way or we're doing this as an easement. The zoning ordinance only states that it has to be a 30-foot easement. Right? "30-foot deeded or legal right of way from the parcel boundary to the state designated public road."
Yeah, and under cemetery, it's worded the same as a 30-foot right away from the state.
Yeah, modeled after that one.
Yeah, and see, we're not gonna, people that's cutting out cemeteries don't wanna give 30-foot strip of land to the cemetery.
Right.
They just wanna make it interesting. Make it- I think it should just reword the fee simple somewhere, where the fee simple would pertain to subdivisions, like class 1 and 2 subdivisions, but not to cemeteries. And see, I just realized that would include cemeteries as
Mhm.
well.
So not to,
Family or single.
well, it would be single divisions, it would be family subdivisions,
Mhm.
cemeteries,
Anything other than a
anything
class
other
1 and 2
than
subdivision.
okay.
I don't think we can strike out right away and just say we've gotta start putting easements in because of, all the other counties that I survey in, I thought we call them right of ways, and then the attorney clarifies what that right of way is in use for. Not saying that they're gaining that piece of property it's a right of way for ingress and egress or whatever.
I don't know how the bank would be on it. They won't loan on an easement. I mean, you've got to have a right of way. I mean, it's got to say.
Yeah, I think it needs to stay as right of way. The fee simple part is.
I knew that was a little touchy for you, and I'm just listening to everybody and listening to their scenarios. It's definitely something that we wanna, we'll talk to
Mr.
Mr. Lockerbie about.
Means ownership. It don't mean I'm gonna let you use this road. It means you.
It means ownership.
You own it.
Okay. Well, I'll come back to you on that one. Cause, that might be an issue somewhere down the road. Okay. Street width, he just removed the word easements. So now it just reads as curbs, guttering, drainage, and planting strips. Is that okay? Are we looking? Okay. Subdivision, a division of any lot, tract, or parcel of land. He did remove the purpose of transfer ownership of development. So subdivision, as we go on down through here, basically is the same thing as a single division. Again, class 1, class 2 development stuff it will need to be moved over to the zoning ordinance. And then class 2, he revised it just for verbiage, basically for fewer than 15 lots. And a class 1 is 15 lots or more. Zoning ordinance, he added it. We've never had that in the subdivision ordinance, so that'll be part of our reference. Article 5, we had it as general administration of the subdivision ordinance. That's kind of what he's added now. He restructured the word administration based off of 15.2-2-2201 because of now becoming the agent. Anybody have questions about that? That is the reason that we are having to redo the subdivision ordinance. No questions? All right, so now the duties of the agent shall perform the task and duties as necessary for the execution of this ordinance. The Code of Virginia, information about the ordinance, associated processes is available in the zoning department. It's a policy change out of that same code, 15.22-2201. Review and approval was struck, very simplified now. Now it takes all of that from the planning commission and reverts it back over to the planning agent or subdivision agent, whatever you want to call it. I think this ordinance says designated agent or agent. What? Yeah. I assume that's what they will do. Consultation was completely struck and rewrote based off the policy change of 15.2-2-2201. Basically, he rewrote it to say that the agent may consult with other professionals in state and federal agencies, including VDOT, Virginia Department of Health, and/or county officials, municipal officials, and utility providers, and other persons in order to properly administer this ordinance. In some circumstances, approval of such agencies, which in this ordinance may be referred to as agency review, is a prerequisite to approval of a plat. Additional authority, clarification again, just says that the planning commission may advise the agent to the extent permitted by law. So that's 15.2-2-2201. If time allows and I've got issues and the law allows, I will definitely be bringing things to you for questioning, just in the event that I might not see something that you guys will see. More minds that look at something can see things maybe that I've missed.
It would just be for advice as opposed to.
Yeah, it would be for advice. Mandatory compliance. Other than that, it was just clarification. Classification standards we're now in Article 6. Mr. Lockerbie just said that the classification standards was consistent with my previous comment. The note that has been addressed carefully under the tetra by the word can stay. It can stay here without a problem. So I think he was concerned about certain impacts, certain wording that was in this particular, but he didn't strike it, so he said it can stay there. Again, subdivision, now referred to as a single division. I think he did exempt that, correct? Yeah. So now makes it makes a single division an exemption, which is a clarification.
So would that need to be added under this, like the exemptions where cemeteries are?
I think so. I think we're gonna have to move that around. And I think he put that there. Did he put, are you looking at the crosswalk? Are you looking at the actual,
The crosswalk.
pretty sure he added, that's Article 6, right?
6-3.
It's not under the exemption, I don't think, unless I'm looking at the older one. It's got cemetery and court ordered
He
partition.
put it under cemetery for subdivision. Cemetery, because I had it under single division exemptions, and he said that that was repetitive. I don't see exemption in here. Under, I think you're right on that. Consistent with my previous comment, note that this is to be addressed carefully under tetra. But the word can stay, and the word use is where he was concerned about, can stay without a problem. Okay, right here under single division exemptions, I couldn't see it for all of the lines. 6-3 is now an exemption, and cemetery is included under that in the subdivision ordinance.
Is the one that you sent, draft 2025?
Yeah, there's a clean version and then there's a working version, but they both say the same thing. And I can't understand why he done that. Clean version to me is clean. It has no comments. But 6-3 states under subdivision exemptions, the following types of subdivisions are exempt from review under the ordinance. A, cemetery. And then he also added B, court-ordered partitions, which was never been in there. Partitions ordered by the court need not comply with this ordinance.
The single division still not under exemption. Are you saying it's included with cemetery?
So they've got subdivision, and then under that, 6-3 is an exemption. And then the cemetery's under that,
But not single division.
not single division. But it's still considered a single division is a subdivision.
But I thought that was gonna be our exemption.
No, I'd still need to look at a single division to make sure that it's got the
Well,
easement
you
or
have to look
right of way.
at- You have to look at cemeteries too. It's just an exemption from class 1 or 2.
Right, yeah, I still look at, yeah, I see what you're saying. I still look at the cemeteries just to make sure that they have the right of way or easement,
Right. And they gotta be named.
and it has to be named.
So that's where I was thinking, that's where I was expecting to see single division, but I don't see single division at all.
It's
We
not
need
on
to
there
keep
anymore
that.
because he struck it. He called it an exemption. I guess that's something I need to talk to him about.
That was my biggest concern with the whole,
I see it now that I'm looking at it with you.
with the whole redoing, you know, I think the single division is a good thing. I mean, it gives people the opportunity to sell off a piece if they do fall on hardships or whatever,
Right.
without selling the whole farm, without it being considered a local subdivision.
The subdivision.
Having to go through all that.
Okay, we'll have to get in there and figure that out. I've got it wrote down to talk to him about. Did you look at the definition? Single division, a division of one parcel into two parcels. I think it needs to be added back.
Yeah, I do too. I mean, I think he's just saying that any division is a subdivision. But that's why I thought that would fit under exemptions. It is we're labeling it as a single division of
Right.
land.
Right.
Which is a subdivision as well, but it's something that we're allowing.
Right. As an exemption, you don't
Right. You don't have to, meet class 1 or 2
standards, right? Okay, I didn't even catch that when I was working through it.
Well, maybe I'm reading it wrong.
It's exempt, right?
Is he just saying,
Only class subdivision or exempt from review under the soil. Single review.
maybe he's not saying we're putting it under exemptions, we're just saying this is exempt from
Being reviewed.
being considered a
Subdivision.
class 1 or 2.
Does it need to be reworded?
But the word can stay here without a problem. Yeah, maybe that's what it's saying.
But still, I need to review those cemeteries. I know they're exempt. They're exempt from a single division. And the single division still needs to be reviewed for access. But the way he's got it wrote, they're exempt.
Yeah, he's saying they're exempt from
From review. And I don't want it to say that.
No.
Or I don't think we had the intent for it to say that. Because we need to make sure the zoning ordinance states that you gotta have that access, whether it's state or state road or right of way. And so that's gonna be applicable for a buildable lot. And that's the purpose of the review, to ensure that these people have that to be able to do with what they want in future. Does anybody else see it any different?
It's not, it's exempt from being reviewed. That's the way I would do it.
Right, that's not the intent.
Right.
What?
Like I'd be arguing, you can't even know.
Because without you reviewing it, then we could cut out anything.
That's right.
Exactly, and never have to come before review. So it could just be recorded and,
But I hadn't thought about the cemeteries being under, but I thought somewhere in here, doesn't it say that the cemeteries, the plat showing the cemetery boundary right of way and official name shall be submitted to the subdivision agent for review. So it's an exemption from a subdivision, but it's still
It's in the ordinance.
subject to be reviewed.
In the ordinance.
Yeah.
that's the way he's got it.
Yeah, that'd be.
But we would need single division in there as a
Yeah,
C or something that would say the same thing. It's exempt from a quote subdivision, but still subject to review by the agent. And then the court orders wouldn't be reviewed by anyone.
it by anyone, because that's court, yeah.
So that just needs added to exemption.
I think you're right,
It's still
yeah,
subject
just,
to review.
that's what I put, still subject to review. All right. We good? And we worked through those details. That was Article 6, wasn't it?
6-4.
Boundary line adjustment. He struck most of it and created it as a boundary line adjustment. Revisions shall not create additional lots or affect any easements or right of way, but merely reconfigure existing lots. Line adjustments shall not create new substandard lots or cause an increase of nonconformance of existing lots or structures of the Grayson County zoning ordinance or the Grayson County building and fire codes. Still has to be approved by the adjoining landowners if it impacts the property lines. Still good with that one? I didn't see any reason why.
I didn't really.
It was
think
just a
so.
clarification in my mind. There's the family division again. We know what we're gonna do there. Farm division, nothing more than just clarification. Less words, same thing. 4 or fewer. Residual parcel, including the other parcels, have to be 10 acres in size. And there's the class 1 and class 2s again. Same thing that we just discussed. That moves us into Article 7 under purpose or procedure of review of final plats was added. It didn't say that. It used to say procedure for review and approval, including design requirements. Now it just says procedure for review of final plats. He struck administrative review and assist landowners and added this article is to set forth the process for review of subdivision plats submitted for approval for final approval and recordation referred to as final plat and for proper design of division. I think that's a clarification just because we didn't have final plats in there before. So my question to you, Mr. Surveyor, do they have to say final plat? Approval and recording referred to as final plat. We've never had that on our surveys before. Have you all had a survey that ever show up that says final plat?
Well, it just says referred to as a final plat.
I mean, I typically will see preliminary when I'm doing a preliminary review, but
Well,
never,
If it's, I mean, if a surveyor signs his seal, then
that's final.
It's redundant to write it. And maybe that ain't even what it is.
Maybe that's not what he's referring to, but I will ask about that. That's Article 7. All right.
And maybe that's just one that's submitted to you. It's just
Referred to as a
cover
final.
sheet says this is the final
Final
plan
plan.
or something, I don't know.
He did quite a bit of striking the word procedure in Article 7. And he done that because of the recent state law changes that have prohibited pre-application conferences from being required. So originally it was suggested that you had to come see me to do a pre-application for a subdivision. We'd sit down, talk about it. He made it say that basically it's suggested. You don't have to, but sometimes it's easier to talk about it beforehand before it actually comes across the desk. It just says may request a pre-application conference with the agent to determine applicable standards and processes. Again, he also noted some localities have done away with this position. What he is referring to is the GIS, the 911 coordinator. Our ordinance specifically talks about the 911 coordinator. We are not a locality that's done away with that. They still provide road assistance for naming and addressing. So it's just a clarification, and I did tell him that 911 is still involved. So I'm gonna leave it as is. A lot of clarification about documents, recorded plats must include references. He talked about septic systems, added systems, or public water, where we just had septic and water. Talks about adding if easements are intended to be dedicated for service by the Grayson County Public Service Authority or other publicly owned systems, a space for signature for that agent and such entity should be added. I'm not sure that we've ever done that with water. We have very limited water resources for the county, but we've always had an AOSE and
Yeah,
need
that's
also.
mostly for like in town or something.
Yeah.
Public.
Yeah.
Okay.
All right. Again, as far as the agent and administrator, he struck that, and now it's considered the agent. The sections 3 through 8 are required by the new state law. So everything that you see in the crosswalk that's highlighted in that blue, that's all has to do with the time frame that's set by the state now when they have to be reviewed. Typically, it would go through the planning process. It can take up to 2 to 6 months. But now it's down to 40 days, 30 days, and then you've got to send it off to the appropriate agencies. They've got a time frame now. So basically it cuts everything basically in half. So all of that, we can't really have any say in. That's new code language. 7-3 is the design requirements. Design requirements were struck, and he added design requirements for final subdivision plats. All subdivision plats, regardless of their classification, subdivision plats, regardless of classification, are subject to review of the following. So a lot of this was struck, other than just road access. He implemented infrastructure improvements and performance bonds, which was part of moving that from section 8.3, just so it would tie into final subdivision review. I think we had that in as preliminary.
It's a lot of words.
It is. It's a lot of verbiage, but it's all been vetted by him, and it's applicable because of now the state law changes. Anybody got any questions on what he added? I'm not sure we can have any dog in the fight over it, but because it must comply with that 15.2.2270 and 15.2.2272. Moving on to Article 8, was renamed from Planning Commission review, approval of Class 1 subdivisions and Class 2. It's now recommended that it say preliminary subdivision replats and planned unit developments. So it'll say procedure for review and approval of preliminary subdivision plats and planned unit developments. There's a new purpose that he added. There was never a purpose. The purpose for this article is to set forth the process for review of submission plats submitted for preliminary approval, referred to as preliminary plat, and for proper design and division of property to achieve appropriate land use and development, in accordance with the zoning ordinance, comprehensive plan of Grayson County. He made a statement that application, it now tracks with state law. A change a few years ago prohibited requirements for preliminary subdivision plats for subdivisions of 50 or fewer. And he also stated in a certain section that we can no longer require erosion and sediment control. It's strongly encouraged because that is precluded from state law. It cannot be required.
And that's what kind of subdivision?
That was just the application. We can't make someone do a consultation with me for erosion and sediment control. This was all pre-consultation stuff. We can't require anyone to do that. But suggested. Excuse me, strongly encouraged. He struck in required application fee. We had 7 days that I had time to review those plats that come across my desk. Typically, I would turn around and do those in the same day. I typically won't make you wait. But now you've got certain time frames according to the new laws. 5 business days from the date of submission. 40 days to approve and deny. Applications to approve and deny, 30 days. So that's another agency. As soon as I get them, I typically turn them over to VDOT, the health department. I don't typically wait around. So I don't feel like this will be a huge impact for the developer or myself. Moving on to crosswalk, Article 8, he did add preliminary plat to show, something that we never had in the language. And this is based off of 15.22262. So now it'll say a preliminary subdivision plat shall show the name of the subdivision, district, county, state, property owner and name, address, signature, and license of the engineer, surveyor, owner, city planner or urban planner, architect, landscape architect. Who prepare the plat, the date the plat was drawn, and dates of the revisions, a north arrow, source of the meridian, scale of the drawing and number of sheets. If shown on more than one sheet, matched lines shall clearly indicate where the sheets join. Generally, location of the proposed subdivision by the insert vicinity map and a scale of not less than 2 inches equal 1 mile, and otherwise approved by the agent, indicating thereon adjoining roads, their names, number, towns, subdivisions, and landmarks. C, proposed names and locations of new streets, and so on. D, references, tax parcel numbers, existing zoning, any proffers, variances, waivers necessary for subdivision, existing zoning adjoining properties. When the subdivision consists of land acquired from more than one source, a title that outlines the various tracts shall be indicated on the dashed lines, and the identification of the respective tracts shall be placed on the plat. The boundary survey and existing survey record. Total acreage subdivided. It just goes on and on and on. And you all have seen it. This is based off of 15.2-2262, which has to be there. 8-3, submittal of the final plat to the Planning Commission. He completely struck. No more of that. He said all this was prohibited by the state law. The Board of Supervisors, he references that Board of Supervisors from Augusta County and Countryside. Completely struck Article 9-1. He completely struck it and suggested that all of that needs to be implemented into the subdivision ordinance because of that particular law.
Zoning ordinance.
Did I say zoning ordinance? I'm getting tired. But all of those design elements in 9-1 struck. Article 9, all of that was struck as well. Will have to be implemented in the zoning ordinance because of the design requirements. 9-2 now becomes 9-1. It's just general requirements. Again, referencing the state laws and the court case between Chesterfield and Tetra. He did add that side lots shall be designed by right angles, radial, street, and other formats suitable for proper layout. Corner lots shall have extra widths as necessary to meet the building line setbacks requirements from both streets and provide proper sight line distance. Condominium and townhouse developments may require greater standards. 5, the condominium and townhouse developments may require greater access and water and sewer services. Number 6 is where land is covered by subdivision includes 2 or more parent parcels in separate ownership. Proposed subdivision may present situation where the property ownership line divides the subdivision. 1 or more of the proposed lots. Every parcel owner involved with the planned subdivision shall submit the parcels for review in tandem with each other, and upon approval of the subdivision shall be recorded and reflected subdivision plat. 9-4 was revised to state all subdivision must comply with provisions of the Grayson County Code, state law relating to erosion sediment control and stormwater management. 9-5, it had a little bit of clarification, and that's where I've got notes to talk to you, Justin. He had some questions about he said the agency folded into NOAA and was abolished in 1970, but I still think there's markers out there. He said you might want to check on this. So my question to you, have you ever seen anything different?
Is that just for the monuments?
Yeah.
What does it talk about?
What did I say that was? 9-5.
9-5,
Yeah, in the ordinance.
8B or something like that? 8C.
I have a note in here, it says number A, it's monuments. A, at least one corner of the subdivision shall be designated by bearing the distance tie from readily discernible reference markers. If a corner is within 2,000 feet of a U.S. coast or geodetic
Yeah, they're just wanting.
geodetic survey station. It says the agency was abolished and folded into NOAA in 1970, but I think there are still markers out there. Do we need to leave that or change it?
So they're just saying they want us to tie into a geodetic marker if it's within 2,000 feet of the site we're working on.
Right.
I don't have to, because I use GPS and my stuff is as good as the markers that they have set up, so I don't know.
I mean, I'm sure they're out there. I'm sure
Yeah,
they're here,
they're-
otherwise it wouldn't have been in here.
I'm not, NOAA is not a US, let's see.
He said the agency was abolished and folded into NOAA in 1970. He's talking about the US Coast Guard
Yeah,
and Geodetic Survey Station.
While he's looking at that, on 9-2 on the lot size, he scratched all that. Was it not have to be 0.688 now?
9 dash where?
It's in 9-2, the lot size.
So he made the note. Can you see, are you looking at the crosswalk or are you looking at the ordinance?
I'm looking at the ordinance. It's
Yeah,
wrote in red with lines crossing.
but do you see where it says move to zoning ordinance? So the lot size still has to be 0.688. But all of these standards, lot size, road frontage, all that has to be moved to the zoning ordinance. So my plan is to copy and paste.
Right.
And then, create new subsections, copy and paste it over, let him vet it and make changes if necessary. No. And Dan asked me if I was busy. On top of some other things that I'll bring to your attention later.
Yeah.
So, yes, Charlie, they'll go to the zoning ordinance. Are you still thinking about that? Do we need to come back to it? Do we need to
Well,
look into it?
I'm just surprised it says US Coast and Geodetic, cause, most everything is USGS.
So I think that's what he's questioning. Do we need to change it to
If
USGS?
anything, we change it to USGS, cause they do have control. Like there's one down here at the church next to the bank that I use.
Okay,
And it might be under the Coast and Geodetic as well, but I know it's under USGS, and there's a lot of those out there.
okay.
But
Still okay if a quarter is within 2,000 feet of USGS survey station,
Survey control or something.
survey control. All right, thank you. And then he had a comment about the pipes. Simple pipes and stakes are more common nowadays, and that's where he's referencing C. The monuments shall be designed as control points and shall be of stone or precast concrete with minimum dimension of 4 inches square, 4 inches in diameter, at least 30 inches long. The monument shall be steel or wrought iron pipe not less than 1/2 inch or more diameter and 18 inches long. The monument shall be flush with the finished grade. Because he just said simple pipes and stakes are more common nowadays. So I guess
I'm
he's.
not sitting on 4-inch concrete on the corner.
So my question is, we probably need to rewrite this for the more modern.
Yeah, I use 1/2-inch rebar on everything.
Okay.
And that
Is that
only-
common standard practice?
Yeah.
Because I have car axles in the ground at the house.
Oh, yeah, that's what they used to say.
So they're easier to find.
Make a metal detector zinc.
Yeah.
But this does say the monument shall be steel or wrought iron pipe. If we could just include iron rod or rebar or something like that would cover it.
Okay.
And the rest could,
Just leave it that way and then,
and all of them are 18-inch. Yeah.
okay. I'll add that section in there. Rods.
There's a couple counties that require 5/8 rebar, but like Florida, I think.
What's this? And A. You'll note that he added number 10 to the subdivision under 9-5, basically because it now has to model after 15.2, 2241A6. And that is, a subdivision is intended for development in industrial, commercial, and residential use. I won't read it. Y'all have it in your hands. And if the public wants to, I'll put this out there because I know we're live. If the public wants to see any of these changes, I do have them available in my office. Moving on, I think it's Article 10. Really and truly, we're getting really close to the end here. Plan unit development. He added that he wanted to know who actually approved the plan unit developments, because he struck the word can and used the word may be approved. And he questioned who actually does the approval. Does it go to the Board of Supervisors in accordance with the zoning ordinance? It has always went to the Board of Supervisors. So I'll have to revise. We've always done subdivisions, have always been signed off on by the Board of Supervisors.
But what about with the law that come into effect? Does
I
that
know.
change that as well, or is that relative to?
I think it's in accordance with the zoning ordinance. It would have to be the permitted in rural farm zone under the rural farm or rural zone district, Grayson County plan unit developments may be approved where the proposed tracts are suitable in location. I guess I need to talk to him a little bit more about that, but the Board of Supervisors have always approved subdivisions. But is that applicable under the new law?
Yeah, I don't think they would now.
That's a lot of, that's pretty heavy. That's heavy for me to have to say, yeah, you can do that without having, I know the lobbyists have been to the legislator and legislation and said, hey, they're holding us up, but I don't feel like that should fall back on, something that huge should fall back on just me.
You need one.
Yeah, I think I need insurance. Actually, I've been told I need insurance. He struck all of 10-3, 10-4, move it to the zoning ordinance. That's designed. He did, however, reserve them in case we ever need to add anything. Design standards, move it all to the zoning ordinance. Like I said, I'm just going to copy and paste, and then we'll let him weed it out. Under the D, he amended it for the Condominium Act, just so that it's compliant with the state code. Moved the maximum height for dwellings for the plan unit development over to the zoning ordinance. Struck planning commission review, stuck it to the agent. When I say stuck it, that's exactly what the state did. Something that we can talk about is Article 11 for fees. Currently, the fees have always been this way, as far as I know. Fees shall be $15 for each subdivision plat and $2 for each additional lot. I think it's Carroll County shows $15. I don't know. I don't know what the going rate is.
Theirs is 100 now.
$150, I think, is what I saw. $150 for a subdivision review.
For review.
What do we charge?
15.
15.
Maybe it's a typo. Maybe you're supposed to say 150.
Yeah.
That's it.
Yeah, we've always been, our fees have always been very, very laxed. And I'll be honest with you, I've never collected a fee, one, every time we've ever done a subdivision review. I've maybe $55 is all I've ever collected. So it's something that we can probably discuss if y'all come up with a solution. But I did check Carroll counties just because they have it. I don't know what City of Galax is for subdivision review, but we're definitely not compatible with our surrounding jurisdictions. I can come back to you with a proposed itemized,
Those big copy Carol.
at least, yeah. That way,
Don't copy them too close.
don't copy them too close. I think he revised manufactured home and recreational parks, that's, Article 12. He just fixed a typo there. We had it as, anyway, he fixed the word vehicle. Not sure how that got by us. Article 13, requirements for preparation of final subdivision plats. He removed planning commission review. Stuck it to the agent. Just kind of done some typo work corrections because some of that stuff is repetitive. Talks about the recording of the approved plat shall operate to transfer in fee simple. The county, the portion of the premises platted as in on the plat set apart, streets, alleys, and public uses and transfers to the county and easement indicating the plat's created public right of passage over the land. Have you looked at that one?
I've got lost where we at.
Article 13. I know we kept talking about in fee simple. Just make sure that you don't see anything that I'm not seeing in number 4.
Where's fee
He
simple?
added it, he said it's changes to Virginia Code 15.2, 2265. I don't think there's any,
No, that's what I was talking about for any subdivisions that's gonna create
In
new
fee
streets
simple.
and stuff, it would be in fee
Fee
simple
simple.
to the county.
okay, and he states that that's in compliance with the code. And then he added verbiage about the agent approves the plat or replat of land therein. Then upon the recording of the plat, the replat, all right-of-ways, easements, and other interests of the locality and the land included in the plat or replat, except as shown thereon, shall be terminated and extinguished, except that the interest acquired by the locality by the condemnation, by purchase, for valuable consideration, and evidenced by a separate instrument of record, streets, alleys, easements, and public passage of subject provisions of 15.2, 2271, 15.2, 2272 shall not therefore be affected. But the county does not own or maintain any streets. Let me be clear on that. So I think it's just in there for
If they were,
code purposes.
if they were to be dedicated to
Yeah.
the county.
And then nothing else other than some Article 13. Article 14 just clarifies the code of Virginia. Article 15, it returns, he struck vacate and said vacation of plat. Nothing more than clarification. Verbiage, Article 17 did not change, and Article 18 did not change.
For reference, he did say, this is Ronald Newman. He said dealing with 2 parcels, so the plat fee would be 200, even though that was on one plat. It was 2,
So you got 2 parcels on one plat,
it was a boundary line adjustment.
it's 100.
It must have been 100 feet.
I don't charge for any of that. The county doesn't charge for any of that.
I think that's excessive.
I think that is excessive. It takes me all of, what, Justin, 30 minutes as long as, less than that. If I have to do any kind of, digging around in the clerk's office, less than 30 minutes. I actually think I could see it if it was a subdivision plat, but not for like a subdivision class 1, when I say that, class 1, class 2 PUD, maybe. That's where
Yeah,
you would
that's gonna
charge,
take some time.
not for boundary line adjustments, single divisions,
Gonna take-
farm divisions, cemeteries. There should be no fees for that. That's just a courtesy to ensure that our land use development is in compliance with our subdivision and zoning ordinance. I think should be just part of the job.
Well, there ought to be a fee for the subdivision.
Yeah.
One,
And then I
two.
think that's where the
PUD.
fees come in, and I'll look at
But
that.
this was a boundary line adjustment
Really?
on one map.
Does the attorney pay that? Or it comes on in closing costs? Or
No,
does the homeowner and the
Get it
new,
recorded for review to get it stamped to record. So the owner or owners,
Whoever's doing it.
whoever's having it done.
that's excessive.
I think so. That shocked me, as I didn't even want to tell them that. Survey didn't cost.
Okay, so do you all feel good with what's been, I know that's a lot, and I know we went through a lot of pages of subdivision ordinance, but we got it all. You feel good with what he's recommended? I mean, a lot of it is law. It has to be implemented because of that new legislation that came down in 25.
As long as they're single divisions.
As long as that single division is in there, and I've got my notes about the
Right away.
right of way, the fee simple, single division, had a question about the final plat. I just want to make sure that was just verbiage. And then the rods and rebars, if we just add that in there, and then the fees. I'll come back to the planning commission next month with that tied up. Hopefully we get those loose ends tied up. And if you're good without all of those, we can go into public hearing.
I'm good.
You're good. And that's a lot. I've put a lot on you. But I just want to let you know that there's a lot more coming.
So we
Because
have
of these changes, we have to implement the new zoning, we have to implement it to the zoning ordinance. So I'll have to copy and paste it over to the zoning ordinance. You've got to do the whole review. Of course, it'll be vetted before I bring it to you.
Other than adding this stuff or transferring it over, is there changes gonna be made?
To the zoning ordinance? Yes. And I bring that up, the new legislation that is in process right now for 2026. There has been a lot of lobbyists in regards to the utility solar.
Oh, yeah.
So there are some things in our zoning ordinance that will now have to be, all the work that we did for 2 years ago for the utility, wind and solar, now has to be modified to meet the new standards. However, the new governor has yet to sign it into law, but
Oh, that's kind of.
we're waiting for that to happen. But I'm already preparing for it because my hope is when we do this change for the zoning stuff, we can incorporate the utility scale stuff too, in addition to the comprehensive plan. So I have a couple of resolutions. I went on and done this because basically technically we shouldn't be reviewing, well, I say technically, we can start the process, but I don't want to catch the new board of supervisors off guard because I'm hitting them hard come April. I have a smart seal project that I've got to redo for Mount Bell and 89. I have this subdivision ordinance, so I'm hitting them with a resolution for the planning commission to do the work so that they know that we're working on this, in addition to the zoning ordinance for utility scale, for the design requirements for class 1, class 2, and PUDs in the zoning ordinance, and the comprehensive plan amendments so that they'll model after the policies will model after the new requirements for utility scale. Just know that I'm trying to hit it all so that we can only hold one public hearing. In addition to that coming next month, we'll also be doing a rezone for Crest Haven Farms.
Is that to deal with their,
Dr. Tomlinson is wanting to add an animal clinic to this parcel that's outside of the conservation easement. I know that Justin is working on a survey for that, and he's supposed to get that to staff so that I can get it started. So,
did you say that all this stuff we just went through has to go to a public hearing?
yes, sir.
That ought to be interesting.
I know. But I wanted to let the board of supervisors know in April that the planning commission is already working on it. But I want to be as transparent as possible. We're working on this because we have to. It's law. And so we're only making these changes because of the law. We're not trying to add or create more hardship. We're just getting our ordinance up to par.
In compliance.
In
with the law.
compliance with the law. And it's just making more work on us to get it there. But I didn't want them not know what we're doing. So
Honestly, there's not that big of changes to it.
it's not, but I was really shocked. We've not done an update to our subdivision ordinance, overhaul to the subdivision ordinance since May of 8th, 2014. So pretty doggone good just to, but the big change is planning commission doesn't review a lot of the developments. It falls back into the agents of lab.
Do we need any kind of action or just thank you?
I've got to get you the answers, and then my hope is I will get you the answers, and then if you want to put it to a vote that I think I need to come back with the revisions. I want the board of supervisors to know in April what the planning commission's doing, because I want them to pass a resolution giving the planning commission the authority to start work. Although we're already working on it, and we can do that based off of the code section. It allows the planning commission by motion to start working on something. So we're still in compliance with the law. I just wanted to jump the gun and not wait on their approval, because we have a lot to do. This has to be done before July 1st, in addition to the zoning ordinance and comprehensive plan.
Does it have to be done by, or we're gonna try to do it all?
We've got to get it done before July 1st when it takes effect. This stuff's already in effect. It's just not in our ordinance.
Crest Haven Farm shouldn't present any problems, should it?
It shouldn't. I know we're going to rezone it to commercial. I know most everything around it is rural farm, but for what she's wanting to do, it makes more sense to do a rezone, because otherwise, if she wants to make a change, every time she makes a change to a special use permit, she's got to come back here. I think it's redundant and it's not necessary.
Okay. You have been busy.
A little bit.
Oh, the next item everybody should approve is adjourn. You have anything else?
No, I just wanted to give you that as a staff update, what's coming down the pipe. And that's not to scare you off. So I still need a quorum. I need you to show up. I'll try to make it as easy as possible.
Do I hear a motion to adjourn?
So move.
Second? Second. All in favor, say aye. We done.
Thank you all for your time.